The war I couldn't win in Afghanistan finally caught up to me in a Florida suburb when my HOA told me I couldn't build a wheelchair ramp because it would decrease property values. I'm Daniel Reeves, 34 years old, former Marine Corps sergeant, Iraq veteran, and since an IED blast in Helmand Province took my legs below the knees in 2019, a double amputee who uses a wheelchair for distance and prosthetics for short mobility. After 2 years of surgeries, rehab, and learning to live in a body that no longer worked the way it used to, I was finally ready to move forward with my life. My fiancée Jessica and I bought our first home together in Coral Gardens, a planned community in Boca Raton, Florida. The house was perfect, single-story, 800 square feet, 3 bedrooms, 2 baths, wide hallways that could accommodate my wheelchair. There was just one problem: 3 concrete steps from the driveway to the front door. The realtor assured us this was easily solvable. You can install a ramp. People do modifications all the time. Just get HOA approval. It's mostly a formality. That formality turned into a 2-year legal battle that exposed a conspiracy of discrimination, revealed millions in HOA fraud, and ultimately changed Florida law for disabled homeowners across the entire state. But I'm getting ahead of myself. We closed on the house in March 2023. Jessica and I spent the first month unpacking, painting, making the space ours. The house was beautiful. Spanish colonial style, tile roof, cream stucco walls, arched doorways. Coral Gardens prided itself on architectural consistency. Every house followed strict Mediterranean design guidelines that the community had maintained since its construction in 2005. I could appreciate the aesthetic. What I couldn't appreciate was the 3 steps that made entering my own home an ordeal, requiring Jessica's assistance every single time. In April, I contacted a contractor recommended by my VA case manager. Mike Sullivan specialized in ADA-compliant home modifications for disabled veterans. He came out, assessed the situation, and proposed a simple solution: a modular aluminum wheelchair ramp professionally installed, with a gentle 112 slope meeting all ADA requirements. Will it match the house? Jessica asked, already anticipating HOA concerns. We'll paint it to match your stucco exactly, Mike assured her. You won't even notice it's there except for the functionality. And legally, under the Fair Housing Act, the HOA can't deny this. It's a reasonable accommodation for disability. I trusted Mike's expertise. He'd done hundreds of these installations. I submitted the modification request to the Coral Gardens HOA on April 15th, including detailed architectural drawings, ADA compliance documentation, contractor licensing and insurance medical necessity letter from my VA Dr. Fair, Housing Act legal citation. I expected approval within the standard 30-day review period. Instead, on day 29, I received a 1-paragraph email from Richard Hastings, the HOA Architectural Review Committee chairman. Your modification request has been denied. Exterior ramps do not conform to Coral Gardens' Mediterranean architectural standards. Please consider interior modifications or alternative accessibility solutions that maintain exterior aesthetic consistency. Richard Hastings, ARC chairman. I read it 3 times, not quite believing what I was seeing. They just told a disabled veteran he couldn't access his own home because a wheelchair ramp wasn't pretty enough. Jessica found me sitting in the garage staring at my phone. What's wrong? I showed her the email. Her face went from confused to furious in about 3 seconds. They can't do this. This is illegal. You're disabled. You have rights, and they just did it. Then we appeal. There has to be an appeals process. There was. Sort of. According to the HOA covenants, denied modification requests could be appealed to the full board at the next meeting for a $500 administrative review fee. The next board meeting was 6 weeks away. In the meantime, I continued struggling with those 3 steps every single day. Some days were better than others. Some days my prosthetics fit well enough that I could manage them with just a cane for balance. Other days, when the phantom pain was bad or my residual limbs were swollen, I needed my wheelchair, which meant Jessica had to help me transfer at the steps. It was humiliating. Not because I was disabled, I'd made peace with that, but because my own community was forcing me to be dependent when a simple ramp would have given me independence. I started researching. The Fair Housing Act, enacted in 1968 and amended in 1988, explicitly prohibits discrimination based on disability in housing. The law requires HOAs to allow reasonable accommodations and reasonable Modifications for disabled residents. Wheelchair ramp for a person who can't walk is about as reasonable as it gets. I also discovered that Florida had additional protections. Florida Statute 760.23 specifically addressed disability discrimination in housing and set strict limits on HOA authority to deny accessibility modifications. Armed with this information, I prepared for the board meeting. I drafted a formal appeal citing Fair Housing Act Section 6 SORF 3B, requirement to permit reasonable modifications Florida Statute 760.23, state-level disability discrimination prohibitions, Americans with Disabilities Act Federal Accessibility Standards 8th Amendment, to Coral Gardens Covenants, ironically added in 2021, stating the HOA would comply with all federal and state disability laws. I also brought Mike Sullivan, my contractor, who could explain the technical aspects and aesthetic mitigation measures. The board meeting was held in the Coral Gardens Community Center on a Tuesday evening in June. The room was set up theater style, with about 40 residents in attendance. The 7-member board sat at a table at the front. Richard Hastings, ARC Chairman, Margaret Whitfield, HOA President, Donald Chen, Treasurer, and 4 at-large members I didn't recognize. Margaret called the meeting to order and worked through standard business, budget updates, landscaping contracts, pool maintenance reports. 40 minutes in, she finally got to my appeal. We have an appeal of an ARC denial regarding a proposed wheelchair ramp at 2847 Coral Way. Mr. Reeves is here to present his case. Mr. Reeves, you have 10 minutes. I wheeled to the front of the room. Jessica squeezed my shoulder as I passed. I'd worn my Marine Corps dress blues, chest full of medals, Purple Heart prominent, because sometimes you need to remind people who you're dealing with. Good evening. I'm Sergeant Daniel Reeves, United States Marine Corps, retired. I lost both legs serving this country in Afghanistan. I live at 2847 Coral Way with my fiancée. Our house has 3 steps from the driveway to the front door. Without a wheelchair ramp, I cannot independently access my own home. I pulled up my presentation on the screen. I've submitted a modification request for an ADA-compliant ramp that would be painted to match the house, professionally installed, and fully code-compliant. The ARC denied this request citing aesthetic concerns. I'm here to explain why this denial is illegal. I spent the next 8 minutes walking through the Fair Housing Act requirements, Florida law, and the specific accommodations we'd made to address aesthetic concerns. Mike Sullivan added technical details about how the ramp would be designed to blend with the architecture. When I finished, Richard Hastings didn't even pretend to consider it. Mr. Reeves, we appreciate your service, truly. But Coral Gardens has architectural standards that have been in place for 20 years. Allowing one resident to bypass those standards, even for a sympathetic reason, sets a precedent that undermines the entire system. Have you considered moving to a single-story home without steps? The room went silent. Did you just suggest I sell my house because you won't let me build a ramp? I asked slowly. I'm suggesting there are alternatives to violating our architectural guidelines. Jessica stood up from the audience. You're violating federal law, the Fair Housing Act. The Fair Housing Act allows reasonable accommodations, Richard interrupted. We don't consider a large exterior ramp that fundamentally alters the visual character of a property to be reasonable when alternatives exist. What alternatives? I asked. You mentioned interior modifications. My house is already single-story. The only barrier is exterior steps. An interior modification doesn't solve an exterior problem. Margaret spoke up. Perhaps you could use the garage entrance? I don't have a garage entrance. My garage doesn't connect to the interior of the house. Then perhaps a portable ramp, Donald suggested. Something you could put in place when needed and store when not in use? Portable ramps for 3-step rises are unstable and dangerous. And I shouldn't have to assemble and disassemble a ramp every time I want to enter my own home. The board members exchanged glances. Then Margaret said, We're going to take this under advisement. We'll provide a written decision within 14 days. Thank you for your presentation. That's it? You're not going to vote? This requires further deliberation. Meeting adjourned. They moved on to the next agenda item as if I wasn't still sitting there. Jessica and I left, both furious and stunned. 2 weeks later, the decision came via certified mail. After careful consideration, The Coral Gardens HOA board has voted to uphold the ARC's denial of the wheelchair ramp modification request. While we sympathize with Mr. Reeves's situation, we must balance individual needs against community standards. Alternative accommodations remain available. This decision is final. Margaret Whitfield, HOA president. That's when I called a lawyer. Attorney Jennifer Martinez specialized in disability rights and Fair Housing Act litigation. When I explained the situation, she was both sympathetic and angry. Dan, what they're doing is textbook illegal. The Fair Housing Act doesn't give HOAs discretion to deny reasonable disability modifications. A wheelchair ramp for a person who can't walk is the definition of reasonable. We have an open and shut case. How long will litigation take? 6 months to a year, probably. But we can file for preliminary injunction immediately, which would force them to allow the ramp while the case proceeds. That hearing could happen within weeks. Do it. Jennifer filed the federal lawsuit 3 days later. Reeves v. Coral Gardens Homeowners Association. Incu's alleging violation of the Fair Housing Act. Florida Fair Housing Act and Americans with Disabilities Act. The complaint sought injunctive relief requiring the HOA to approve the ramp damages for emotional distress and loss of enjoyment of property attorney's fees and costs punitive, damages for willful discrimination, the preliminary injunction. Hearing was scheduled for 3 weeks out. In the meantime, something unexpected happened. The story got picked up by local news. A reporter from the Boca Raton Tribune had been at the board meeting and reached out to me for an interview. The resulting article, Disabled Marine Denied Wheelchair Ramp by HOA, went viral locally, then nationally. Within 48 hours, I'd been contacted by CNN, Fox News, and MSNBC. The story hit a nerve. Decorated war veteran, obvious need. Heartless HOA denying basic accessibility. The coverage brought out supporters and, surprisingly, other Coral Gardens residents with their own HOA complaints. I started getting emails. Dan, I'm Linda Chen on Palmetto Drive. The HOA fined me $5,000 for repainting my front door without approval, even though I used a pre-approved color from their own palette. They're running a scam. This is Robert Martinez. They denied my request to install solar panels, claiming they violated aesthetic standards. But I have photos of 3 other homes with panels that were somehow approved. It's selective enforcement. Dan, it's worse than you know. I used to be on the board. Richard and Margaret have been siphoning HOA funds for years through fake vendor contracts. I tried to report it and they forced me off the board. That last email came from someone named Thomas Wheeler. I called him immediately. Thomas was in his 60s, retired corporate attorney, had lived in Coral Gardens for 12 years and served on the board for 5 until he was pushed out 18 months ago. Dan, you stumbled into something bigger than a ramp denial. Richard and Margaret run Coral Gardens like a personal fiefdom. They control the board, manipulate elections, and use HOA funds as their personal checking account. How? Fake vendors. Inflated contracts. They own a property management company, HMS Property Services. The HOA pays HMS $180,000 annually for services that should cost maybe $60,000. That's $120,000 a year in embezzlement disguised as fees. Why didn't you report this when you were on the board? I tried. I presented evidence at a board meeting. Within a week, I was removed from the board on manufactured grounds. They claimed I'd missed too many meetings, which was false. Then I started getting violation citations for every minor thing. Painted mailbox the wrong shade, lawn grass half an inch too tall, Christmas lights up one day past their deadline. They fined me $8,000 in 6 months. I eventually just paid it to make them stop. Will you testify to this? Absolutely. If you're taking these people down, I want to help. I brought this information to Jennifer. She was skeptical at first. It seemed like conspiracy theory. But when Thomas provided financial documents he'd saved from his board tenure, the pattern was undeniable. HMS Property Services, owned by Richard Hastings and Margaret Whitfield, received $180,000 annual management fee, $45,000 for landscaping consultation. HOA already paid a separate landscape company, $125,000, $23,000 for emergency repairs with no documentation of what was repaired, $37,000 for legal consulting, despite the HOA also paying a law firm total, $285,000 annually in payments to a company owned by board members. Jennifer amended the lawsuit to include allegations of fraud, breach of fiduciary duty, and pattern of harassment targeting residents who questioned board authority. The preliminary injunction hearing happened on July 19th in Federal District Court. Judge Patricia Morrison presided. The courtroom was packed. Local news, veterans advocacy groups, disability rights organizations, and about 40 Coral Gardens residents. Our side presented medical documentation of my disability, ADA compliance plans for the ramp, and testimony from disability rights experts explaining why the denial was discriminatory. The HOA's attorney, expensive white shoe firm partner named Bradford Stone, argued that architectural standards were legitimate, that we hadn't exhausted all alternative options, and that forcing the HOA to approve modifications would set dangerous precedent. Judge Morrison cut him off mid-argument. "Counselor, I've reviewed the Fair Housing Act case law extensively. Courts have consistently held that wheelchair ramps are per se reasonable modifications for individuals who cannot navigate stairs. Your client's aesthetic concerns don't override federal civil rights law. What alternative would you propose that would actually allow Mr. Reeves to access his home?" Bradford fumbled. "Perhaps interior renovations? He doesn't have an interior barrier. The barrier is exterior steps. How does interior renovation solve that?" "Your Honor, the HOA's architectural guidelines are subordinate to federal law. I'm granting the preliminary injunction. Coral Gardens HOA is ordered to approve Mr. Reeves's wheelchair ramp within 7 days. Installation may proceed immediately." The courtroom erupted in applause. Judge Morrison actually smiled before continuing. "Furthermore, I'm ordering expedited discovery regarding the fraud allegations. Mr. Stone, your clients will produce all financial records, contracts, and communications related to HMS Property Services within 30 days. This court takes allegations of HOA corruption seriously." I wheeled out of the courthouse with Jessica beside me, both of us in tears. We'd won. I could build my ramp. Mike Sullivan had the ramp installed within 2 weeks. It was everything he'd promised. Professionally done, painted to match perfectly, sturdy and safe. The first time I wheeled up that ramp independently, entering my own home without help, I actually started crying. This shouldn't have been a battle. But since it was, at least I'd won the story. Would have ended there except for what Jennifer's fraud investigation uncovered. The expedited discovery revealed that Richard and Margaret's embezzlement was even worse than Thomas suspected. Over 8 years, they'd stolen approximately $1.4 million in HOA funds through their management company and fake vendors. But there was more. Jennifer discovered that my ramp denial wasn't random. Richard and Margaret had a pattern of denying modifications to residents who might scrutinize HOA finances. Educated professionals, attorneys, accountants, engineers, anyone who might understand financial irregularities and ask questions. I was flagged as high risk because of my military background. There were actual emails discussing how veterans with leadership experience posed oversight threats to board authority. They hadn't denied my ramp because of aesthetics. They denied it because I represented potential threat to their criminal enterprise. Jennifer brought this evidence to the U.S. Attorney's Office. Federal prosecutors opened a criminal investigation into mail fraud, wire fraud, and conspiracy to defraud. Meanwhile, the full civil lawsuit moved forward. Discovery revealed 15 other residents who'd been targeted with excessive fines or denied legitimate modifications after questioning board actions. We moved for class action status. Judge Morrison granted it. The case became Reeves versus Coral Gardens HOA et al., representing 47 residents who'd been harmed by the board's corrupt practices. Richard and Margaret tried to settle quietly, offering $200,000 to make everything go away. Jennifer told them to go to hell. The trial lasted 3 weeks. Evidence included financial forensics showing $1.4 million in embezzlement email chains discussing targeting problem residents, testimony from 18 homeowners about discriminatory enforcement expert testimony on Fair Housing Act violations, criminal referrals from federal prosecutors. The jury deliberated for 4 hours and returned a verdict. Liability, guilty on all counts. Compensatory damages, $2.7 million divided among class members. Punitive damages, $5 million against Richard and Margaret personally. Attorney's fees, $890,000. Richard and Margaret were financially destroyed. The criminal trial resulted in convictions for mail fraud and conspiracy. Richard got 4 years federal prison. Margaret got 3 years. Coral Gardens HOA had to completely restructure. New board elected. New management company hired. Financial controls implemented. An architectural review policy reformed to comply with disability laws. My personal settlement from the class action was $127,000. I used it to establish the Reeves Foundation for Disabled Veterans Housing. Rights. Providing free legal assistance to veterans facing HOA discrimination. 2 years after my ramp was finally installed, Florida passed the Reeves Amendment to state fair housing law, establishing expedited judicial review for disability accommodation denials and imposing mandatory penalties on HOAs that violated disability rights. Today, I still live at 2847 Coral Way. The ramp is still there, perfectly maintained, allowing me independent access every single day. Coral Gardens is a different place now, actually managed in residents' interests rather than board, members' bank accounts, and I've helped 63 other disabled veterans across Florida fight HOA discrimination and win. Sometimes the battles we fight at home are just as important as the ones we fought overseas, maybe more important because these battles are about making sure the country we defended actually lives up to its values. I didn't get to choose losing my legs, but I got to choose not accepting a community that treated my disability as an aesthetic problem, and that choice changed everything.